I'm going to try through my talk to first of all look at what whistleblowing protection is supposed to do, and then look at where it's got to as things stand. Forgive me for spending a little bit of time looking at the relevant statutory provisions, and then we'll look at some of the recent case law, both on approach and, I suppose, the breadth of the application of whistleblowing protection, and finally have a quick look at the future. First of all, whistleblowing's in the news at the moment. There's coverage about whether there should be greater protections, whether in light of some of the concerns that were raised about the grooming gangs recently and a failure to act on them, whether there should be wider casting of whistleblowing protections. There's currently a bill before Parliament, the Office of the Whistleblower Bill. There's been talk about there being specific individual appointed to hold the office of the whistleblower in order to provide those protections in a different way. As things stand, as I'm sure you all know, in order to bring a claim in relation to whistleblowing, you have to be a worker, at least a worker. The protection under Section 43A is for someone who is at least a worker. Now, the current guidance that I could find on the government website about how wide the protection applies says the Act protects most workers in the public, private and voluntary sectors, and then says the Act does not apply to genuinely self-employed professionals other than in the NHS, voluntary workers, including charity trustees and charity volunteers, police officers, or the intelligence services. And what I want to do in this talk is look at whether that actually rings true, whether the guidance that in theory is coming out from government, and so to tell us really what the Act does, whether that is consistent with what the courts have told us in relation to the protection for whistleblowers. So looking first of all at the statutory provisions, it's the Limbb worker test that we get from Section 233B. And unpackaging that provision a little, in order to have protection, we need someone either working under a contract of employment, and you'll perhaps be pleased that I'm not going to go into Uber and Aslam and questions of exactly what that means, but looking at perhaps the other sections there, we have working under any other contract, whether express or implied, and inevitably when you're getting these kind of cases on the desk, if you have a written contract, that will be of significant assistance in you trying to understand whether or not you might have protection for someone as a worker. Next, whether they carry out work or services personally, and then if they do so, whether that work is being carried out for the third party as their client or customer. If they're carrying out that work for the third party as client or customer, rather than as worker for the potential employer, then that cannot be someone who qualifies for worker status. So that's the legislation as it stands. Where we also will find there is important guidance comes from the Convention rights, the freedom of expression right under Article 10, and the right under Article 14 to be able to enjoy the rights under the Convention free from discrimination. And you will see under Article 14 the familiar protected characteristics that we all know of sex, race, colour, language, religion, political or other opinion, national or social origin, association with a national minority, but then some that a little less familiar, property, birth, or other status. And as we'll see, or other status has led to a category of protection which is perhaps something which allows for a substantial widening of those who are treated as falling as Limbb workers, at least for the purpose of whistleblowing claims. So next, looking at the approach as it currently is, and whether that's changed. The two cases that I want to talk about are Gillam and Sharp. So Gillam was a relatively recent case that went to the Supreme Court, and it concerned District Judge Gillam. District Judge Gillam sought to bring whistleblowing complaints, and the question for the court was whether or not she could, whether she satisfied the definition under the Limbb worker test. So in the Supreme Court, it was held that the Court of Appeal was right, that she couldn't satisfy the definition of that Limbb worker test. But nevertheless, she should be treated as doing so because of her convention rights. And so it held that the particular occupational status enjoyed by judges meant that they should be read into the Limbb worker test and be able to bring a whistleblowing claim. And you can clearly see that that is a widening of the test. So unpackaging that a little bit, what was held was that the claimant's right to freedom of expression under Article 10 and her right to enjoy the rights in the Convention without discrimination on any ground, including on other status, the status here being her occupational classification, meant that Section 233B should be read so as to include the holder of a judicial office. Now, that of course doesn't just mean district judges, realistically. On the face of it, it means that all judicial office holders are protected from whistleblowing through the whistleblowing protections under the Employment Rights Act. And working in the way in which the test was applied, it wasn't in dispute that the judge undertook to perform work personally. It wasn't suggested that those that were receiving the work were the client or the customer of the judge. It wasn't an issue that the judge was a statutory office holder. And Baroness Hale said that the relevant question was, and this, it seems to me, will apply in many cases outside judicial office holding, was whether the parties intended to enter into a contractual relationship, defined at least in part by their agreement, or some other legal relationship, in the particular case defined by the terms of statutory office of district judge. And what she said was that you should look at the manner in which the judge was engaged, and so in any one of these cases, look at the manner in which the individual has been engaged, the source and character of the rules governing that person's service. Are they rules that have been negotiated between the two and set out the relationship between them, and therefore contractual? And then look at the overall context, although it was said that's not an exhaustive list. What was found was that without the intervention of European law, without the intervention of convention rights, the essential relationships between judge and I hesitate to use the term employer, were derived from statute and were not a matter of choice or negotiation. And it was difficult to identify the claimant's employer, not really the MOJ, not really the Lord Chief Justice. Hard to say exactly who it is that employs the judge. And then the constitutional context of separation of powers as between judiciary and government meant that the Section 233B test couldn't be met. But then the Michelak test was applied, the test of whether or not you should allow convention rights to be read in, the Michelak test being first, do the facts fall within the ambit of one of the convention rights? Whistleblowing is likely to fall within the right of freedom of expression. Next, has the claimant been treated less favourably than others in an analogous situation? Well, were the claimant an employee, she would have had whistleblowing protection, and so it would appear less favourable treatment. Third, is the reason for that less favourable treatment one of the listed grounds or some other status? And here the other status was occupational classification. And finally, is that different treatment without objective justification? And so the Supreme Court held that allowing for that other status position to show that there was discrimination here on the grounds of freedom of expression, on trying to whistleblow, it meant that you should read in a protection for a judge whistleblowing. Now, of course, we're all lawyers in this room. Trying to argue that occupational classification is other status, and therefore various different occupational classifications could fall within whistleblowing protection, is not something that is a great stretch for any of us. You can see that the other status wording could be expanded really quite wide. What I think now must be the approach to take when trying to work out whether someone who comes to you is protected in a whistleblowing claim. So first, whether they've got a contract of employment. Next, if they work under any contract, express or implied. So have the parties chosen to enter into a contractual relationship? And in doing that, look at how they were engaged, look at the source and character of the rules governing the service, the overall context, and any other relevant factors to the particular case that you're looking at. It will be important to consider whether the claimant undertakes to perform work personally. And so the right of substitution question that we'll be familiar with is still written large in the test. Next, look at whether they're actually providing that work to their own client or customer. If they are, then it's unlikely that they'll fit. And then, even then, in light of Gillam, if they can't satisfy the Limbb test, you'll need to look at the European questions, the Michelat questions. Is one of the claimant's convention rights engaged? Probably freedom of expression. Next, have they been treated less favourably than others in an analogous situation? Next, is the reason for that one of the reasons in Article 14? And bear in mind that includes the other status reason. And then, can that difference in treatment be objectively justified? On the face of it, Gillam would suggest that the courts are willing, where they consider it appropriate, to expand those who fall within worker in order to provide whistleblowing protection, a purposive approach. There is a marked contrast between that approach in 2019 and the approach in Sharp and Worcester Diocesan Board of Finance in 2015, not that long beforehand. A case in the Court of Appeal where Lady Justice Arden, when deciding that it was right that a clergyman was not a worker or employee, said a court may be reluctant to hold a person to be an employee or worker if that conclusion required a development of the existing law. And she made reference for that principle to Johnson and Unisys, which is the case that decided that unfair dismissal rights shouldn't be expanded so as to include a damages claim for injury to feelings or psychiatric injury. The point being, if the legislature had intended that, then the Act would say so. Arguably, you could say, in whistleblowing protection, applying the analogy provided by Lady Justice Arden, by finding that someone who is an office holder and not a worker or employee is in fact covered by the law, the Supreme Court was taking the opposite approach to that which appeared to be advocated only a matter of 4 years beforehand in Sharp. So looking at how that approach has played out, first of all, Rainford and Dorset Aquatics is a case where someone was found not to be a worker. Rainford and Dorset Aquatics was where you had a director shareholder. And there are lots of cases that we will all see where you have a small company with director shareholders who have been paid a wage, and it's quite difficult to work out exactly whether they're an employee, whether they're a worker. On the particular facts of this case, it was held that Mr. Rainford was not a worker. But what was clear is that a director shareholder could be a worker if the facts were sufficient to demonstrate it. So had there been enough to show that there was a contract for personal service then that may well have meant that, in fact, Mr. Rainford was a worker. Some of the principles that come out of that judgment, which are useful, I'd suggest. First, there's no reason in principle why a shareholder director can't be an employee or, of course, a worker. It's a question of fact each time. And for every single case, in truth, not just one where you're looking at director shareholders, you will need to look at how the parties have actually conducted themselves. How have they arranged their affairs? Have they set them out in a way that it suggests that there is a contract for service? If it's inconsistent with such a contract, as it was found to be here, or at least it was found the ET could find it to be here, you don't have that situation. Made clear that the existence or lack of a written employment contract is going to be an important matter. And interestingly, the court went far enough to look into what they considered to be the purpose behind whistleblowing protection, and said that the primary underlying question in all these cases is one of statutory rather than contractual interpretation. And it was said the relevant statutory purpose of the Employment Rights Act and other employment legislation is the protection of workers who are vulnerable because they're in a relationship of subordination and dependence toward their employers. And a touchstone of subordination and dependence is the degree of control exercised by the putative employer over the work or services performed by the individual concerned. And so you can see that where you have a director shareholder is essentially deciding what they do, on that kind of analysis, it might push away from the idea of employment or worker status. But one might say that that kind of analysis would push away from a judge falling within an extended, or there being a basis for a judge falling within the extended idea of worker, because the whole point of the judiciary is that they are supposed to be independent and not subject to control. And you can see the tension in the way in which these cases have to be looked at. Perhaps an obvious bit of guidance from the case, a genuine right of substitution is inconsistent with personal service. If there really is a right to substitute, you're probably outside worker. The next case then is a holiday pay claim, not a whistleblowing one, but because the working time regs have the same worker test, one that it would appear would translate across. So this case concerned a panel member and chair of fitness to practice panels for the Nursing and Midwifery Council. And he sat on panels when asked to for a fee. He didn't have to sit when asked. He could choose whether or not he sat on any one panel. He could choose whether he accepted the dates or not, and provided that he gave a sensible amount of notice, he could return a case having said he'd take one. A very similar arrangement, you might think, to very many part-time disciplinary panel type roles. It was held in the case that there were two contracts, one of which was an overarching contract under which he wasn't a worker. That concerned the provision of training, the guidance that he got, the original appointment. There was no obligation under that to offer or seek work. There was no obligation to personally perform work. And so under that contract, worker test not satisfied. However, it was also held that each time that he did take a case, an individual contract arose where he was a worker, because he had agreed contractually that he would carry out the service personally. He was remunerated for the service that he was carrying out. And so the Court of Appeal upheld the judgment that for each of those small contracts, he was a Limbb worker. On the face of it, therefore, part-time chairs or panel members of disciplinary panels may well have whistleblowing rights as against the party that contracts with them to provide those kinds of services. In my case, that would be the FA and the RFU. It appears that there may be many other of those kinds of examples where whistleblowing protection might apply. CAT and the English Tennis Table Association. Here you have a non-executive director. He was found to be a worker. You'll recall the guidance that's still there on the government website that rather suggests that's not what the legislation intended. Mr. Catt was elected as a non-executive director of English Tennis Table Association, and he brought a whistleblowing claim. The ET found he wasn't a worker and dismissed the claim. His appeal was allowed by the EAT with some fairly strong guidance, and it was remitted to a tribunal who then did find that he was a worker, which is not terribly surprising when you read the wording of the EAT judgment. The EAT judgment included, first of all, that it wasn't in dispute that he undertook to personally carry out his non-exec duties. Next, no suggestion that the respondent was his client or customer. Next, that there hadn't been a clear finding on whether or not there was a contract in place. And while some questions had been answered, the ET hadn't looked at his position as an office holder and the factors that he said suggested he was a worker, which were whether or not he was required to work or perform services for the respondent as an integral part of its business, yes. Whether he had to provide his personal input on strategic matters, yes. And in fact, he was required to commit 15 to 20 days' work per year, receiving payments of £1,500 a year. And so a non-executive director can be a Limbb worker under the Employment Rights Act. The label that appears to be attributed to any particular role seems far less important than the analysis that you need to carry out with particular regard to what the specific contractual relationship is in place if you realise when looking at the relevant tests that there is a contractual relationship in play. Moving on, a case in which one of our colleagues was involved at first instance, Groom and Maritime and Coast Guard Authority, is a case that concerned a volunteer. The case was purely about the right to be accompanied to a disciplinary hearing. That right is something which workers are entitled to, as well as employees. The case is subject to appeal, but a volunteer here was found to fall within the statutory test for a Limbb worker. He was a volunteer for the respondent's Coast Guard Rescue Service. The particular agreement, which was in writing, was described as voluntary. You might think that some lawyers have been involved in drafting it. The volunteer handbook included that no contract of employment existed, that membership of the Coast Guard Rescue Service was entirely voluntary, and that meant that there was no mutuality of obligation. Fairly obvious what people were aiming at when drafting that document. There wasn't any automatic remuneration for any activity. You had to ask for that remuneration. And it was held that when someone was volunteering, the degree of control was not significant. Those things combined with a revenue investigation for tax purposes where it had been found that there were volunteers at first instance before the ET was found to be enough to say not worker. But the EAT disagreed. And they said that whether or not someone is a worker doesn't depend on what someone's written in a handbook. The use of the term voluntary needs to be looked at in the context of the arrangement. And so again, look at the particular arrangement in a particular case, look at the facts, don't look at the label applied. In this case, it was held that the reality is that these volunteers made a claim for payment whenever they did most of the activities concerned, and if they made the claim for payment, they were paid for it. It may have been their option, but they had a right to payment. The sum paid was an hourly rate of remuneration for services offered, and the reality of the relationship was that they were, in essence, when they worked, entering into an agreement to be paid for the work that they were doing at an hourly rate on the basis it was them doing that work. Worker. And in fact, that analysis, of course, is not dissimilar to the analysis which meant that a part-time disciplinary chair, when carrying out work for which they were remunerated, fell within the Limbb worker test. So volunteers, and granted it's up to the organisation whether they describe them as volunteers or not, but volunteers can be Limbb workers. The most recent case that deals with the convention right extension is the case of McLennan and British Psychological Society. Here you have a charity trustee. The charity trustee was president-elect and about to become president and raised whistleblowing concerns, grievance raised against them, and in due course they were expelled. It was claimed that as a charity trustee, they were entitled to be treated as a worker and have whistleblowing protections. The ET held not a worker. The EAT upheld the ET's analysis that there was no intention to enter into a contractual relationship, and so there was no error of law. However, what was decided was that the convention rights hadn't been looked at carefully enough. And the broad brush approach, which is the terminology used, needed to be applied to the question of whether the claimant was in an analogous situation to an employee or Limbb worker, and whether holding an office as a charity trustee was some other status, ways in which that analysis should be carried out, and whether potentially the person should have convention right protection. One of those being the availability of alternative routes to make disclosures of wrongdoing, where someone is in a position where they would become aware of wrongdoing that they ought to be able to report. And Judge Taylor held that there was a strong argument that being a charity trustee in this type of case was akin to an occupational status, but left that matter to be dealt with by a new tribunal on it being remitted. Now, I can't find another tribunal decision in McLennan, and the case was remitted back in October 2024, and so it looks like that decision having been made, the case was probably settled. But on the face of it, that means, and certainly the EAT judgment is fairly clear, that charitable trustees can fall within, with the convention extension, a category of occupational status that means that they should receive Limbb worker protection. So the guidance said the protections don't apply to genuinely self-employed professionals, voluntary workers, including charity trustees and charity volunteers. It's previously been thought that non-exec directors wouldn't be protected. The reality is it seems that the case law takes us quite a lot further than the level of protection that you would currently find explained on the government website. And so, looking to the future, the Office of the Whistleblower Bill brings in the idea of the Office of the Whistleblower, who is specifically to provide protection for whistleblowing. The idea is that an individual in an office will be able to provide additional protection for whistleblowers from retaliation for raising matters that are genuinely in the public interest. Now, if that bill comes to pass, and as things stand, it was due for a second reading in July, but it's been postponed to next May, you could see that some of the justifications for reading in through the convention rights a requirement that certain categories should be treated as workers may go away, because we may in UK legislation have a protection for workers that means you don't need to provide that kind of extension in order to ensure that someone's right to freedom of expression is protected in some way before the UK courts. But that is probably something for some time in the middle of next year.